Maybe you've already gotten an offer from the insurance company after a dog bite. Maybe it's $5 or $10 or even $20 or $30,000 if it was a really bad bite. And you might be asking yourself, is this really what my case is worth? And that's a fair question, especially if you're still dealing with medical bills, or your kid is still having visible scars or wounds that haven't fully healed, or you're just plain rattled every time you see a dog. So in this video, I'm going to walk you through 6 different dog bite cases that settled for above 6 figures. We're going to walk through these cases so you can see exactly what pushed them into the 6-figure results range and how to recognize those value drivers in your own case. In our first case, a woman was riding a 3-wheel motorcycle when she crashed into a black lab that darted into the road. She suffered a torn rotator cuff and ACL damage to both knees. Now, strict liability didn't apply because there was no bite. If you've watched any of my other videos, you might know that in states that have adopted strict liability for dog bites, you don't need to show the owner did anything reckless or careless, only that the dog bit you. But the statutes can be narrow. They can typically only cover injuries caused by an actual dog bite or an attack. Like in Missouri, where this accident happened, the strict liability statute only applies when the dog actually bit someone. So strict liability didn't apply here to this case because the dog who caused the crash didn't bite the woman, just ran out in the road in front of her. But that isn't the only legal theory available under Missouri law. This case was reframed as a negligence case, and that just means that the plaintiff had to show that owners failed to take reasonable steps to prevent a foreseeable risk. It's not about proving the dog was vicious, it's about proving the owners were careless. The focus of the case shifted to what the dog owners knew and failed to do. The dog had a history of getting loose. At the dog owner's full-time residence, the owners kept the dog in a fenced yard because they understood it might cause an accident. But at their lake house where this accident happened, they left the dog unattended without any containment, no fence, no supervision. Now, there was no local leash law in this case, and the defense leaned hard on that. But the plaintiff established that the owners were aware of the risk of letting their dog out and be loose, and they failed to act responsibly in this context. That was enough to defeat summary judgment and push the case to settlement. The case ultimately settled at mediation for $265,000. The key strategic takeaway here was understanding which legal theory actually applied. Strict liability wasn't going to work, so the case had to be built on negligence instead. Knowing how to leverage the right law and avoiding the one that doesn't fit is what made this a 6-figure case. Our next case was a strict liability case in Missouri, so there was no battle over fault. The question was just value, and it involved a 69-year-old woman who was visiting a friend when a pit bull attacked her without warning, biting her in the face. The injuries on this one were brutal, deep facial and oral lacerations that required more than 100 stitches. She was left with permanent scarring and had to get plastic surgery. The claim ultimately settled for $150,000 without having to file suit. And at first glance, that settlement might not seem like much given the severity of the injuries. But according to the woman's attorney, she had a remarkable recovery. The plastic surgery was successful and she didn't have any long-term problems. And the adjuster leaned on that really hard to negotiate the value down. So what really drove the value here were the photos taken immediately after the attack, before any healing had begun. Those photos gave the adjuster a clear, visceral understanding of what happened and how bad the attack really was. This was especially important because the woman had such a great recovery, and you'd never be able to tell by looking at her today how badly she'd been attacked. So this case shows that in strict liability jurisdictions where you don't have to prove the owner was negligent, your focus should shift to presenting the damages in a way that sticks. Graphic, immediate, well-documented photos can do more for value than just about anything else. And it can make it hard for the insurance company to argue the case down. Our next case happened in Kansas, where a 7-year-old girl was bitten in the face by a neighbor's dog while she was playing outside. She suffered lacerations on her right cheek, nose, and lip, along with puncture wounds on her left cheek and forehead. She was left with a thick, jagged facial scar that will require future plastic surgery to fix. Her medical bills were under $3,000. Now, Kansas follows the one bite rule, meaning that the victim has to prove that the dog owner knew or should have known that the dog was dangerous. And one of the most common ways you can prove that is by showing that the dog has bitten someone else before. That's how the one bite rule got its name. If the dog hadn't bitten someone before, then the dog essentially gets one free bite before the dog owner can be held liable. But here's where people kind of get tripped up by the one bite rule. Despite the implication of its name, you don't actually have to prove that the dog bit someone before to win your case. In Kansas, for example, the law says that you just have to show that the dog owner knew or should have known that the dog was vicious before the bite happened. The challenge in this little girl's case was that there was no documented history of any prior bites by the dog that bit her. And if that was what she was required to prove, she would have been out of luck. But she was still able to win her case by focusing on proving that the dog owner was on notice of the dog's vicious tendencies. She found a neighbor willing to testify that the dog had snapped at people before and had a nasty temperament. So that girl's attorney then used that testimony to argue that the dog owner knew or should have known that the dog posed a risk of harm to others and should have been confined so it didn't hurt anyone. This was enough leverage to negotiate a $170,000 settlement for that little girl. And that money will support her future medical care, including the plastic surgery that she's going to need. This case shows the importance of doing legwork to find credible witnesses who can speak to a dog's past behavior. That neighbor's testimony wasn't just helpful, it was essential. It helped show the owner knew that the dog might hurt someone, which created a legal duty to prevent it. The other key lesson here is knowing the nuances of your state's dog bite laws, especially in one bite rule states like Kansas. These laws are often misunderstood, and how you prove what the owner knew can make or break your case. Our next case involved a woman who was attacked by a friend's pit bull the moment she stepped into the house. The dog wasn't secured like it normally was, and it knocked her down and mauled her leg, severing a vein and exposing her tibia. She spent 3 days in the hospital and racked up about $27,000 in medical bills. Surgery was limited because the wound couldn't be closed due to the risk of infection, and the result was extensive tissue damage and severe scarring. Her future medical costs were estimated to be about $24,000. Now, this case was filed in Missouri, which, as we know from our prior examples, has a strict liability statute for dog bites. That meant that fault wasn't an issue, but the plaintiff's attorney still leaned into the fact that the dog was usually kept in the basement. That confinement history suggested that the dog owner knew that the dog could be dangerous, even if she wasn't legally required to prove that. So even though it wasn't technically required under Missouri's strict liability statute, the fact that the dog was usually kept in the basement helped show the dog owner understood that the dog could be dangerous, and that detail made it easier for the jury to connect the dots and see that the owner recognized the dog was a threat. And while strict liability doesn't demand proof of fault, juries are more likely to award full damages when they believe that the owner was actually in the wrong. And that fact helped push the insurance company to pay the policy limits of $200,000. Our next case involved a 3.5-year-old who was bitten in the face while she was trick-or-treating. The bite caused permanent scarring and a condition called animation deformity, which is where the scar visibly shifts with facial movement. Now, this case also happened in Missouri, where we know that there's a dog bite statute that imposes strict liability, but only if the bite happens without provocation. Now, the word provocation becomes a wedge in cases involving children. The defense often tries to argue that the child provoked the dog even when the child is very young. Now, this case ended up going to trial, and the defense argued to the jury that the child provoked the dog by tugging on the dog's leash. The child's legal team then countered that argument with a dog behavior expert from Ohio State who testified that tugging on the dog's leash did not constitute provocation, and instead, the dog was stressed and agitated by all the Halloween trick-or-treaters. Now, the jury awarded $250,000 to the child, but reduced it by 25% for comparative fault, resulting in a final award of $187,500. Now, this case shows how the right expert can make or break the outcome of the case. The plaintiff's expert helped neutralize the provocation defense and protect the child's claim under Missouri's strict liability statute. And even though the jury assigned 25% of fault to the child, the family still recovered a substantial verdict. In Missouri, comparative fault doesn't eliminate a claim, it just reduces the recovery. So even if you or your child had some fault, a strong expert in a solid case can still deliver meaningful compensation. The next case we're going to talk about is heart-wrenching. This one involved a 2-year-old child who was attacked by a German Shepherd at his grandmother's home in Missouri. The injuries were among the most severe you'll ever see in a dog bite case. Degloving of the scalp, full thickness facial lacerations, multiple punctures, ear injuries, and even a possible spinal fracture. The child had to be life-flighted and underwent emergency surgery. Now in this case there was no litigation, there were no depositions, no experts needed. The attorney for the family documented the injuries, gathered the medical records and photos, and made a demand. The insurance company paid the $1 million policy limit without much hesitation at all because serious injuries command serious value. When the harm is obvious and catastrophic, the insurance company knows it's not worth the risk of trial. That's why the policy limit was paid without a fight. But there are 3 big takeaways here. First, serious injuries only result in serious compensation when there's a real source of recovery. In this case, the grandmother had a $1 million homeowner's insurance policy. If that coverage hadn't been in place, it's unlikely the family would have pursued her personal assets and gotten the same result. Second, even if the dog bite involves a family member, you can still bring a claim without causing family conflict or drama. That's because it's insurance, not the family member who pays the settlement. The grandmother in this case probably wanted her policy to do exactly what it did, which was take care of her grandson. Third, when the injuries are severe and the case is well documented, you don't always need to go to court. When the value is obvious and the risk of trial is high, an early smart demand can lead to a full policy settlement without ever having to file a lawsuit, which can save you the time and expense of litigation and often result in more money going in your pocket. These cases aren't just stories, they're blueprints for how dog bite cases get real value. We look at injuries, what kind, how bad, how well are they documented. We talked about liability and how the law applies differently in each state. And we saw how critical it is to have insurance in place. And we broke down how strong facts, good timing, and the right legal strategy made these cases settle high. That's what drives outcomes. And when you understand how the different pieces of the puzzle fit together, you can start to reverse engineer what makes a 6-figure outcome possible. If you want to know where your case stands, get in touch. Use the link in the description below to get a free legal strategy call. We'll help you understand the value of your case and the steps you can take to make sure you or a loved one is legally protected. Thanks for watching. See you in the next video.